So good afternoon or good evening or greetings to everyone. This is another installment of the Athens Public International Law Discussion Group, which we have started this year, where we meet and discuss with scholars from all over the world, actually, being that we're moving into a hybrid mode of communication. We are very happy and honored today to have Professor Makane Moise Mbengue of the University of Geneva with us, an excellent expert in many fields of international law, in particular investment law. My colleague, Professor Linos-Alexandre Sicilianos, will be moderating the discussion, and our discussant to what Professor Makane has to say will be Assistant Professor Anastasios Gourgourinis, an expert in our faculty in international economic law and investment law. So I welcome you on behalf of the Athens Public International Law Center. I thank again Professor Makane Mbengue, and I will turn the floor to my colleague, Professor Sicilianos.
Thank you very much, Professor Papadakis, DFA, for giving me the floor. It is an honor and a pleasure to receive today Professor Mbengue, who is, as you said, a professor at the Faculty of Law of the University of Geneva. He's also the director of the Department of International Law and International Organization. We have the pleasure to cooperate within the Institute of International Law, of which he is a member. He is also a member of the Curatorium of the Hague Academy of International Law, and he acts as counsel in disputes before international courts and tribunals, in particular the International Court of Justice, and in investment cases. And as advisor for governments, he is involved in negotiations of several international investment agreements in Africa. So he is one of the persons who is better placed to analyze for us an issue of utmost importance, namely the Africanization of international investment law. We have also the pleasure to have with us our dear colleague Anastasios Gourgourinis, who is assistant professor at the law faculty of the University of Athens. He is specializing in international economic law. He is also a research fellow at the Academy of Athens. He holds a PhD from University College London, and he has published extensively in issues related to investment law. So he is better placed than all the other colleagues of the faculty to be the discussant of Professor Mbengue. So I would like to give the floor without further ado to Professor Mbengue. He will develop his subject, then Assistant Professor Gourgourinis will analyze and present his comments, and then the floor will be yours, so as for you to have the opportunity to ask questions to both our speakers. Professor Mbengue, you have the floor with great pleasure.
Thank you
so
very
much for coming.
Thank you so much, Madame la Présidente Pazartis, Monsieur le Président Sicilianos, dear Anastasios, dear colleagues and friends, good afternoon and good evening to everyone. It's really a privilege and an honor for me to intervene today in the context of the Athens Public International Law Center. I would like to thank very much both Professor Pazartis and Professor Sicilianos for the invitation. As Professor Sicilianos was indicating, I would like today to share a few experiences, but also a few thoughts on the idea of the Africanization of international investment law and whether it is a myth or a reality. Let me maybe start by saying that Africa is at a turning point of its history. Indeed, in March 2018, the member states of the African Union concluded the so-called agreement establishing the African Continental Free Trade Area, the AFCFTA. The AFCFTA is part of the new generation of international economic agreements that we call mega regionals. Why is the AFCFTA a mega regional? Is because it's an agreement that has as an object, as a purpose to actually cover economic integration, economic relation over the entire African continent, so for 55 member states. The AFCFTA entered into force in May 2019, but because of the pandemic, because of COVID-19, it is only since 1st January 2021 that trade under the AFCFTA is operational. So something important to keep in mind is that the AFCFTA is actually characterized by different phases, by 3 phases. The first phase that was concluded in 2018 was about trade in goods and trade in services. So when you hear about the AFCFTA being operational since 1st January 2021, it means that trade in goods is now operational over the entire continent, and trade in services is also operational over the entire continent. The next phase of the AFCFTA process, the second phase of the AFCFTA process, is actually to negotiate 3 protocols. 1 protocol on competition, 1 protocol on intellectual property, and 1 protocol on investment. And it is about the protocol on investment that I want to touch upon during my presentation today, and in particular the challenge in integrating investment laws and investment regulations at the level of the African continent. So last year, the member states of the African Union have actually adopted what we call the negotiating principles of the investment protocol to the AFCFTA. The negotiations have just started a month ago. It's just a month ago that we have started the negotiation, but negotiating principles were adopted already last year in March 2021. And the negotiating principles explicitly indicate that the investment protocol should be used as a tool for the Africanization of international investment law. So the negotiating principle adopted by the member states emphasize explicitly the need to make sure that the protocol would be a tool for the Africanization of international investment law. And then the question is where this concept of Africanization is coming from, and what is the meaning of this concept or this notion of Africanization within the African context. So the concept of Africanization, or the notion of Africanization, can actually be traced back to 2012. In 2012, the African Union member states decided to launch the negotiations of a Pan-African Investment Code. We usually call it the PAIC, P-A-I-C, the PAIC, the Pan-African Investment Code. And the Pan-African Investment Code can be considered as the beginning or as the roots of this idea of Africanizing or Africanization of international investment law. In 2012, when the African Union launched the negotiations of the Pan-African Investment Code, Africanization referred to 2 aspects. It referred to 2 aspects. The first aspect of Africanization was what I call the harmonization of investment practices in Africa. So this was one facet, one of the meaning of Africanization. How do we harmonize? How do we harmonize all the practices regarding investment regulation in Africa? There was a second facet, a second aspect of this notion of Africanization in 2012, and that aspect was to shape to shape an African voice within the investment regime. So there was not only a regional ambit, there was not just a regional objective behind this idea of Africanization, which would be harmonization of best practices, but there was also a global ambit, making sure that Africa would have a voice, there would be an African voice in the investment regime. So the negotiations of the Pan-African Investment Code were launched, and negotiations of the Pan-African Investment Code lasted for 3 years. So from September 2012 till December 2015. It is in December 2015 that negotiations were finalized. And what I can say is that when it comes to achievements in terms of Africanization through or via the Pan-African Investment Code, one can have, of course, a double feeling. Why? From a substantive point of view, from a substantive investment law point of view, yes, the Pan-African Investment Code has achieved this idea or this objective of Africanization. We were able with the Pan-African Investment Code to agree on the objectives, of investment agreements or investment regulation in Africa. Member states of the African Union agreed that investment regulation has to be done for sustainable development. Also, there was a consensus that investment that would be promoted, facilitated, and protected in Africa should be sustainable investment, which, as many of us know, marks a difference with the dominant model of investment agreements that have been very much focused on investment protection, focused on economic aspects, economic benefits, and not really encompassing sustainable development objectives. So there was a consensus there. There was some sort of Africanization there, because I can say that even before UNCTAD launched in 2015, its investment policy framework for sustainable development, where UNCTAD decided that now it would be important to reform the investment regime and make sure that investment agreements would be oriented towards sustainable development. I can say that in Africa, there was already a strong consensus that the objective would be sustainable investment. Africanization also in terms of rationalization of investment standards. We achieved a very strong consensus with the Pan-African Investment Code that traditional investment standards needs to be rationalized. What do I mean by rationalization? Once again, as many of us know here, the traditional dominant model of investment agreements usually contains very broad investment standards, very vague and very sort of absolute investment standards. The usual bilateral investment treaties would for instance, provide that state parties must grant national treatment, period, or they must grant most favored nation treatment, period, or they must grant FET, fair and equitable treatment, period, or they would also give a broad offer to arbitrate to investors. So the idea of the rationalization of investment standards was to say, yes, some of these standards are legitimate standards of investment protection, of investment treatment, but they can no longer be seen in an African context as being broad, as being large and vague. They need to connect to our developmental objectives. And so with the Pan-African Investment Code, for instance, standards like national treatment were reduced in terms of scope. National treatment would only apply in like circumstances when the foreign investor is in like circumstances with the national investor. Most favored nation treatment would also only apply in like circumstances when for different investors from different countries are in analogous conditions. And where an African touch, an African flavor was put, was that we went as far as defining criteria for like circumstances. And those criteria are very diverse criteria, but for instance, some of them deal with the effects of investments on the local communities, the effects of investment on indigenous communities, the effects of investment on the local, regional environment, and even the effects of investment on global commons. So we made sure that these standards would be connected to developmental needs, developmental concerns of African countries by rationalizing them. But it was not only rationalization that was subject of consensus with the Pan-African Investment Code. We also, with the Pan-African Investment Code, decided to exclude investment standards that we believe are not useful in the African context. And one of them, of course, is FET, fair and equitable treatment. If you look at the Pan-African Investment Code, you won't see any reference to fair and equitable treatment. It's not a mistake. It's not a mistake. It's not that we have forgotten about it. It was conscious that in Africa, FET is not considered as a standard that is actually contributing to a healthy relationship between foreign investors and African host states. So it was not just about rationalization in terms of substance, it was also about excluding what many in this field of investment law sometimes consider even as being customary standards. And the position of Africa was to say, no, we don't need these standards. Pan-African Investment Code also went for Africanization in terms of giving an African content to the right to regulate. We know that one of the major threats that the dominant model of investment agreement is posing is a threat to the right to regulate, because the way we've been doing investment agreements for the last 40 years, 50 years, have prevented many states to actually regulate for public health, to regulate for labor protection, to regulate for environmental protection. So the right to regulate is fundamental. But what we have done with the Pan-African Investment Code was not just what you would see sometimes in some of the EU agreement, which is just to reiterate or to reaffirm the right to regulate, but we made sure that the right to regulate would actually be compatible with African needs. And we went as far with the Pan-African Investment Code. We went as far as formulating investors' obligations. And this is here also another, I would say, African contribution to have an entire chapter in an international investment instrument focusing on investors' obligations. So, of course, obligations that would be connected to the problems, to the challenges that African countries are facing when it comes to investment. So anti-corruption obligations, socio-political obligations, because we know that in the African context, sometimes foreign investors are involved in the destabilization of regimes. They are involved in coup d'etat. So you would find socio-political obligations. You would find obligations regarding the use of land, that it's not possible for foreign investors to actually appropriate the lands, and in particular the lands of local communities. Human rights obligations, corporate social responsibility or obligations. So we went as far as listing those investors' obligations that would give more bones and more teeth to the right to regulate, at least in the African context. So all that to say that there was success in Africanizing investment law from a substantive point of view. However, and this is why I was talking about the double feeling when it comes to the Pan-African Investment Code, we failed. We failed in building an African vision, an African common vision on investor-state dispute settlement, on ISDS. There was failure to consider what would be a proper framework for ISDS in the context of Africa. Many divergent positions among the member states who were negotiating the Pan-African Investment Codes. You had those countries that were totally even opposed to the mention of ISDS, to the mention of the possibility of investor to to initiate dispute settlement mechanisms, in particular internationalized dispute settlement mechanisms against African states. And even for those who would agree that ISDS should be incorporated in the Pan-African Investment Code, they disagreed on what should be the forum or what should be the format of ISDS in the African context. Should it be limited to national courts? Should it be brought before regional courts, or should it be dealt with by traditional institutions like ICSID or under ad hoc arbitration via UNCITRAL rules? So no consensus. And then what happened? By December 2015, when we finished negotiating the Pan-African Investment Code, the only provision that was in brackets was Article 42 of the Pan-African Investment Code. That was actually entitled Investor State. I still don't know what investor state means because it doesn't say more clearly what it's about, but it was entitled Investor State, showing the all controversies and disagreements that have characterized discussions regarding ISDS there. And it's because there was no consensus on ISDS in the Pan-African Investment Code that at the end, in April 2016, the member states of the African Union decided to adopt the Pan-African Investment Code, not as a treaty, but as a code, as a model, because if you read the Pan-African Investment Code, you would see that it is drafted as a treaty. There's even a provision dealing with reservation at some point. So it was negotiated, drafted as a treaty. But the reason why it was at the end not adopted as a treaty was because of the failure to agree on ISDS, to come with an African common vision, Africanization of ISDS. And this is what prompted the member states of the African Union to adopt the Pan-African Investment Code only as a model. So you may ask yourself, why has it been so hard? Why has it been so hard to actually build consensus, to actually shape an African voice on investment arbitration in particular, and ISDS in general in the context of the Pan-African Investment Code? Well, you understand the difficulty when you pay attention to the complexity or the fragmentation of the African investment law landscape. When you look at the panorama, when you look at the African investment law landscape, you will see that investment regulation in Africa is based on 4 layers. The first layer is what we call national investment legislations. Out of 55 African states, out of 55 African Union member states, 47 of them have what we call national investment legislations. Each of those national investment legislation incorporates clauses on investment arbitration, and of course, do not go in the same direction. That's the first layer of regulation. Second layer of regulation, investment contracts. A lot of foreign investors who would come to Africa are actually regulated in their relations, in their interaction with us states, are regulated by investment contracts. The major characteristic of these investment contracts is that they are usually quite obscure. They are not very transparent. They are not even made public. But these investment contracts also contains investment arbitration clauses, which quite often mix investment arbitration and commercial arbitration. That's the second layer of regulation. Then you have a third layer of regulation, which is, of course, bilateral investment treaties. Bilateral investment treaties. African countries have concluded about 850 bilateral investment treaties. So out of the 3,000 plus bilateral investment treaties that have been concluded in the world, 850 of them have been concluded with African countries. And these bilateral investment treaties, as we know, also contain their own system of ISDS. They usually contain very broad offer to arbitrate, and they go in a direction which is not similar to investment contracts and which is not necessarily similar to what is in national investment legislation. So that's a third layer that is complicating things. And then last but not least, you have a fourth layer of investment regulation in Africa, which is the regional one, and which is making things even more complicated. In Africa, we have 8 regional economic communities that we call the RECs. In the north, we have the Arab Maghreb Union. Then in the Sahara, we have the Sahel-Saharan Community of States. Then in West Africa, we have the Community of West African, the Economic Community of West African States. Then in Central Africa, we have the Economic Community of Central African States. Then you go to East, you have the East African Community. Then you go to the Horn, you have the IGAD, the Intergovernmental Authority for Development. Then you go in between East and South, you have the COMESA, the Common Market of Eastern and Southern Africa. Then you go deep South, you have the Southern African Development Community. So we have all these 8 regional economic communities. And guess what? Each of those regional economic communities today is engaged in investment lawmaking. Sometimes via soft law approaches, other times via hard law approaches, treaties, but they are all engaged. And these regional economic communities, of course, also have their visions of how investment arbitration should happen at the level of a region. And so, for instance, they push forward the idea of ISDS, of investment arbitration before regional courts. You know, I always smile when I hear about the idea of a permanent investment court as being a European Union ID. Well, the idea of having investment disputes being settled by a permanent court it can be traced back to what was done already in certain regional economic communities since 2007. For instance, with the COMESA investment treaty. So it's not an invention of the EU. Maybe the multilateral aspect of the permanent court, yes, but permanent court solving investment disputes is surely not an invention of the European Union. So you see, you have these 5 layers of investment regulation that go in different directions and that incorporate different approaches to investment arbitration. And this is what explains the all fragmentation, the all complex mosaic, which then makes it harder to find convergences, to find what we would call an African voice on ISDS. But I see that my time is almost out, and I would like maybe just to share another element on this idea of Africanization. Why, beyond these aspects that I have just described, the fragmentation of investment regulations, why today it has become hard to really achieve this Africanization of international investment law? One as a reason of the difficulty is it's the perception of Africanization as such. If you go to certain parts of Africa, countries consider that Africanization is a contracting in process, meaning building a bridge with the universal framework, building a bridge with the rest of the global community. Some countries believe that Africanization doesn't mean clinical isolation. It means, yes, building on African practices, but connecting them to what is being done at the universal level. And this is what explains why, for instance, certain countries like Angola recently negotiated a bilateral investment treaty with the European Union, even accepting the idea that dispute would be settled by a multilateral permanent investment court if one day it is established, despite the fact that we are negotiating an investment protocol in the continent. So you have those that I call, the bridging countries, those who are into a contracting in process. Then you have other parts of Africa where countries are actually into a contracting out process, meaning exiting the universal investment regime, exiting the global investment regime. No more conclusion, no more negotiations of investment agreements, for instance, with non-African partners. This is the example of South Africa. But it's not just limited to moratorium of freezing of negotiation. It goes as far as what I would call the resurrection of the Calvo Doctrine. It goes as far as the resurrection of the Calvo Doctrine, where these countries would believe that it's all about domestic laws, that investment regulation has to be solely governed by domestic laws, the return to Calvo, and then investment disputes should only be settled by domestic courts, and that no internationalization, at least outside Africa, should occur. You have countries like that. This is the option taken, adopted by South Africa since 2015, when South Africa decided to terminate all its bilateral investment treaties, and which now relying only on its South African national investment legislation. But it's not only about resurrecting Calvo, it's also about resurrecting the battle for the new international economic order. Many of us here remember, the battle for the new international economic order that occurred in the 1960s and 1970s in the UN, when developing countries actually complained that the international economic system inherited from colonization was unfair, unjust to developing countries. And remember that one important moment of that battle for the new international economic order was the adoption in 1962 of Resolution 1803, permanent sovereignty over natural resources. Permanent sovereignty over natural resources. Today you have countries in Africa, for instance, Tanzania, which in 2017 has adopted a new law entitled Permanent Sovereignty over Natural Resources, where Tanzania is basically saying that all contracts, all investment contracts regarding the exploitation of natural resources that are contrary to the interest of the people of Tanzania will be terminated. And disputes regarding those contracts cannot be settled by foreign courts. Foreign courts means international arbitral tribunals. And that's why you have today cases against Tanzania for violation of investment agreements because of that law. Well, allegations of violations, it's not me who's saying that, it's the investors that claim that there are violations. So you see that what makes it more complicated in terms of this Africanization is the different perception of what Africanization also mean within the continent. And I will just conclude to let Anastasios come and bring some elements, and I can come back on some other elements on how today we are seeing this difficulty of Africanization even beyond Africa in multilateral settings like the WTO, like UNCITRAL, where now the failure to Africanize things is being palpable at that level. But just as a conclusion, I would say that yes, there are difficulties. There are difficulties in achieving the Africanization of international investment law, but I don't believe that those difficulties should lead us to think that this all Africanization is a myth. I still believe that to a certain extent, there is a reality. There is a reality behind the Africanization, but it's just that it is a reality that is process-based, that it's not from today to tomorrow that we can achieve that. But I think that there is really a desire to get there. And for me, what I think is the most important aspect is that at least this idea of Africanization has allowed today to make African countries being rule makers in the investment regime, and no longer just rule consumers or rule takers in the investment regime. And I think that this is the positive element of this all Africanization process, making sure that Africa contributes to the investment regime, and in particular in these very critical times of reform of the investment regime. So thank you very much for your attention. And Anastasios, I'm looking forward to your comments and reactions. Thank you.
We thank you very much, Professor Mbengue, for this really exciting analysis and presentation of the issue of Africanization of international investment law. You have spoken about the Pan-African Investment Code, the PIKE. You have spoken about sustainable investment, the rationalization of investment, the need to meet African concerns about development, the fact of excluding the fair and equitable treatment clause, the right to regulate, the reaffirmation and of this right, the anti-corruption obligations, socio-political obligations, human rights obligations, and then you have spoken also about the difficulties in achieving Africanization. You have spoken about national investment legislation, investment contracts, BITs, regional level, and about the fragmentation. I like very much your expression about the resurrection of the Calvo doctrine. So it has been a fascinating analysis. I thank you so much, but I'm sure that my dear and esteemed colleague Anastasios Gourgourinis will have much more to say. Anastasios, you have the floor.
Thank you very much, Mr. Chair. First of all, let me again express my joy for being able to comment on what Makane, Professor Mbengue has very eloquently posited just before. So I will try and keep it as succinct and brief as possible. Now, if one would, Professor Mbengue raised many points, and I will try to group them in a series of questions, issues. So the first one that comes in mind is whether indeed complexity or fragmentation of investment regulation at the regional level is an issue or a virtue. My second issue or remark is whether indeed we are heading towards a domestication of international investment law, and to what extent all the works taking place in the Arab continent are set a paradigm for this shift. And the third is whether, especially given the latest evolutions in global life, the dramatic ones, to be more exact, whether a new international economic order, the thing that it was not achieved in the 60s and the 70s and perhaps becomes more pressing today, whether a new international economic order can be, let's say, not necessarily achieved in the midterm, but at least aspired for the long term. Now, let me start tackling the first issue I just said regarding complexity, or what Professor Mbengue said as the fragmentation, the different approaches within the context of Africanization of international law, whether this is an issue or a virtue. For someone who has not been as involved, someone who has been only an observer to the works inside the context of Africanization, like me, I say that I am always impressed by the breadth of the analysis and by the breadth of the issues being tackled. And I would say that at the regional level, these attempts far exceed other regional attempts. For example, the attempts in the ASEAN, in Northeast Asia, or even in terms of if you enter into an analogous appreciation, into a proportionality appreciation, even the ones taking currently place in the context of the European Union. But given that all these three, I just mentioned, regional attempts to regulate investment are taking place in parallel, concurrently, it is perhaps it's possible to draw some parallels. Now, the first parallel, which touches upon complexity, is whether indeed the dispute settlement mechanisms, the traditional ones available under international investment agreements, are adequate or not, or whether perhaps we should move towards a more nuanced approaches. Now, here, this is an example where complexity becomes a virtue, because international investment law has sometimes been characterized as, until a sleeping beauty, meaning until 1990s, we had only a limited number of investment claims. And the attention that international investment law attracted was limited because of the limited number of cases. So suddenly, in the late 1990s and early 2000s, we had a spike in the number of cases. And as a result, all those dramatis personae in the field, meaning states, investors, law firms, to be fair, started realizing the framework, the legal framework that had already been put into place and waited for exploitation. So if one takes a look at the older generation bilateral investment treaties, he would be most probably criticizing them for being not complex enough, for being very generic, because it was perhaps one of the reasons for the backlash against investment arbitration, the fact that not only in terms of substantive standards, but also when it comes to procedural routes, investors would rely on the general wording of treaties and provisions, and that would lead to a particular discretion of the investment arbitral tribunals to interpret those rules, and that could lead to cases where the application of those rules would raise eyebrows. Now, fragmentation is also an issue that pertains to Africanization, which Professor Mbengue posed in a very eloquent way. And I really appreciated his reference, very schematic reference, to the 4 layers of regulation, meaning domestic investment statutes, investment contracts, bilateral investment treaties, as well as intra-regional, let's say, intra-regional attempts, or intra-regional regulation, not just attempts, of investment issues. Now, again, I understand that this fragmentation may occasionally lead to difficult scenarios, but to play devil's advocate here, first, this is something that even outside the context of Africanization, even in cases of other BAT involving other capital importing or capital exporting countries, it is already there. Essentially, the whole debate about treaty and contract claims, umbrella clauses, the distinction, if any, between international investment, international commercial arbitration is also part of this dialectic. And as practitioners would put it, this is the reality, this is the legal reality, and this is actually an option which may dictate real strategic choices on behalf of businessmen. So I'd say that, again, this complexity or this fragmentation would be less problematic, at least from the outside. Although I fully concede that from others, from the ones studying Africanization from up close, that would be problematic, especially if one aspires to a more systematic, to a more organized regulation of investment activities in the African continent as a whole. Now, let me turn to the second question, the issue of domestication of investment law. Here, I would say that, again, as is evidenced in other regional attempts to regulate in foreign investment protection, such as the EU, domestication is an ongoing exercise. the Acmea judgment by the Court of Justice of the European Union, or even one would say the attempt to establish a multilateral investment court with all those clearly, purely European influences of how to structure it and how to operate it, all these are, and I really enjoyed what Professor Mbengue said, is a return to Calvo. Now, Professor Mbengue referred to a return to Calvo à l'Africain. I would say that there is also a return to Calvo à l'Européen. And it is very interesting that, and I also appreciated that what Professor Mbengue mentioned, and he is right, about the idea, the first inspiration for a multilateral setting for settlement of dispute between investors and host states. That indeed in 2012 or 2014, in the context of the European Union, we have only started to recover from the process of concluding the Lisbon Treaty in 2009 that actually gave the European Union some competences, and there have been only few visible, to me at least, serious proposals for something that, as I understand from my readings and what Professor Mbengue reiterated, was already an ongoing proposal in the works of the African Union. So this domestication, which is something that I think will come across again in the future, not only in a regional, but also at a universal setting. And some even perhaps argue that this is what is going on currently in the ancestral reform process. This is something which I think we should take a rain check in fully assessing. And I think that the Africanization has already proved to be a very good lab for first conclusions regarding this matter. So I also look forward to see what's coming next. Now, and I promise this is my last point, the new international economic order. Here, I sensed some optimism in Professor Mbengue's, in Makane's reference to the NIEO, and perhaps that this is high time, perhaps we could go there, we could reach. I wouldn't necessarily share that optimism for the same very reasons that the Security Council cannot come up with a decision regarding Crimea and so on and so forth. This is how the UN works. I'm not sure that the UN would work towards changing what Resolution 1803 has established. And what Resolution 1803 has established is a paradigm which is more closely tied, admittedly, to developed country perception rather than to the South. But what I do appreciate is that the WTO is another paradigm of how South-South coalitions may lead to changing the ways negotiators treat liberalization or regulation, international economic regulation, more probably. So, although I wouldn't be very optimistic about a new international economic order, I would be very conscious in accepting that what is happening during the past 15 years in the African continent in the sphere of international economic law is clearly unprecedented, and it is very rich in quality and quantity of ideas and proposals. And of course, this is also due to scholars, to practitioners such as Professor Mbengue, who have been doing an excellent job. So with all that, thank you very much. I hope I have set a number of questions and risks for the discussion. Thank you, Professor Mbengue. Makane.
Thank you very much, Professor Gourgourinis, for your comment. So on the three main points, the fragmentation, complexity seen rather either as an issue or as a virtue, and then the domestication of investment law, as you called it, and finally the issue of a new international economic order, the references to the famous resolution 1803, and you have expressed some caution in respect of Professor Mbengue optimism. So with this, the floor is open. I would like perhaps to give very quickly the floor back to Professor Mbengue to react very quickly. And then in the meantime, if you have any questions, don't hesitate to raise your hand or the small hand you have electronically, this possibility, of course. So, Professor Mbengue, short comments to comments.
Thank you so much. Yes, thank you so much, Anastasios, for all these great comments and a lot of nice food for thought. Just to jump back quickly on what you said about a new international economic order, I think that I share the same moderate skepticism or moderate optimism than you, but I think something that is interesting is that for once in the history of international economic law, Africa has not just been, following trends, because we are now in this era where you have these mega regionals, and Africa is having its own mega regional and not waiting, from external partners to show it the way of having a mega regional, and this is what the AFCFTA is about. Where I think I'm less optimistic than you is on the South-South. The South-South, cooperation, for instance, in the WTO, or this idea of global South. Actually, what we are seeing now in the WTO is that African countries are divided on the negotiations regarding the so-called investment, the so-called framework for investment facilitation. You know that there are negotiations on investment facilitation now, and some African countries are involved in the negotiation, while some other countries are totally disconnected from those negotiations because they believe the WTO does not have a mandate. And what this is showing, this is the first time in the history of the WTO that you have African countries, the African group, not being together, not joining together a process. So, but it's a very interesting point. And then last quick comment on whether complexity is an issue or a virtue. I agree with you that actually complexity of the regional investment instruments in Africa has allowed for convergences. It has really allowed for convergences. If there is a field, if there is a laboratory for Africanization, it's very much at the regional level. But now we need to turn these convergences into, clear added value for the Africanization. If what regional economic organizations are doing is actually subject of competition, when you have ECOWAS coming in investment negotiation and saying ECOWIC is better than COMESA investment agreement, and COMESA saying, oh, we are better than SADC, and SADC saying we are better than the other one, then the all convergences become divergences at the end. So I think this is what we need maybe to hope for, a reduction in terms of competition between the regional economic committees. But thank you so much for all the great comments. It was a pleasure to hear you. Thank you, to listen to you.
Thank you very much. And now I would like to give the floor to Andreas Kulik. Andreas, you have the floor.
Yeah, thank you very much. Makane, thank you very much for this fascinating talk. It's also very good to see a lot of familiar faces and names like Faye and Antonios and so on. Just very quickly, three questions and comments, one of which is more technical and the two others are a little more policy oriented. And the first one, I'm afraid for about 2 minutes when you were talking, Makane, about ISDS, I had to zone out a little bit, so I might have missed it, but I was wondering with regard to the question of enforcement under the AFCFTA. What are considerations there, discussions there? Because as you know, in the European context, there's a lot of discussion, or has been a lot of discussion. If you create, in particular, a court, how do you do these, the enforcement mechanism, particularly under the New York Convention that talks about an arbitral tribunal and all these questions, but also what, as you know, ICSID enforcement is different to enforcement before domestic courts and so on, and the question of challenges and so forth entail a lot of different questions. So what is the discussion there? The second question, I said a little bit broader policy picture, is China plays an enormously big role in Africa with regards to investment and so on. And we know that China is pushing its Belt and Road Initiative and beyond, the kind of European Asian connection also. So I was wondering what role China's presence in Africa plays in the drawing up of an investment protocol, as a matter of fact, and maybe also of specific policies that China might be pushing, and that is a reaction to that, particularly in the context of what China is doing in the Belt and Road in Asia, where they are, adopting a kind of a mix of some, regional court system, investment, arbitration, and so on, fitting to their needs. And what effect might that have in the African context? And then finally, we talked of the Africanization of international investment law and maybe of international economic law specifically. And again, maybe together with the context of China playing an increasingly big role, also a different role than before, because now they're also a big capital exporter, not only importer, and therefore having different interests, obviously. But also with regards to Latin America, opting out of ICSID and pushing their own agenda. So are we seeing kind of a de-Westernization of international investment law to some extent, particularly looking in the future? And how could this de-Westernization of international investment law look like? Thank you very much again.
Thank you so much for those most interesting questions. May I perhaps turn to Professor Mbengue? Makane, you would like to reply, or to Anastasios?
To Andreas?
Yes, please.
Yes, thank you. Thank you so much, Andreas, for the great comments and questions. Maybe allow me to just jump back on the last point you raised, and which I like very much, the Westernization of international investment law. I think it's a very interesting concept, and maybe this is what the new voices within the international economic law system should use, instead of talking about, the Africanization or the Latin Americanization, because at the end of the day, the project is the same, is to detach ourselves from what have been considered as being the dominant standards of investment protection or investment treatment. I think it's a very relevant concept. When you look at the negotiations, at least in Africa, the investment negotiations, as I said, you have this variable geometry. You have those African countries that are still very much Western connected, or that are still very much Western connected, and what they present is not necessarily in terms of de-Westernization, but it's more in terms of, okay, how do we build gaps? How do we build, bridges with those countries? Because at the end of the day, we have plenty of bilateral investment treaties with those countries. We have also plenty of economic partnership agreements with those countries. So if you are realistic, it's very hard to just say I'm out of all this, because all this is there. It's an economic reality. And I was mentioning at the beginning of my presentation the negotiating principles of the investment protocol. The negotiating principles actually explicitly say that we need to look at the best practices in Africa, but we need also to look at the best practices outside Africa. And so it happens quite often in the negotiations, for instance, that, you know, we would refer to CETA. We would refer to CETA, or we would refer to USMCA, or we would refer to CAI, the Comprehensive Agreement on Investment between China and the European Union. So China is there because we look a lot at CAI and the focus on investment facilitation, which is something that China is now pushing a lot for. And this allows me to come to your as a question on China's role. China doesn't have, at my knowledge, a very proactive, at least visible role in the shaping, the design of this future investment protocol. But the shadow or the ghost of China is of course there, because as we all know, in Chinese investments in Africa are very important. China is number 3 in Africa in terms of the number of bilateral investment treaties concluded with African countries. And then of course it means that you cannot ignore. And one aspect that is very much there for the future investment protocol will be investment facilitation. Investment facilitation, going beyond the all investment protection, which still be there, but which is not the only focus, and shifting towards investment facilitation, which is in a certain extent something that China is pushing for very much, as you know, because China is the one also pushing a lot for investment facilitation negotiations in the WTO, and together with Brazil. So China is really there. Now, with respect to the question you asked regarding enforcement, it's not something that hasn't yet been discussed in the context of the investment protocol. What we need to keep in mind is that there was this phase 1 of the AFCFTA, where a protocol on trade in services was concluded, a protocol on trade in goods was concluded, and a protocol on dispute settlement also was concluded. I don't know if you have read that protocol on dispute settlement, but it's cut and paste of the DSU, of the WTO DSU. It is cut and paste of the WTO DSU. So what does it mean? It means that in the first phase of the development of the AFCFTA, we actually only contemplated state-state dispute settlement. State-state dispute settlement, and on the basis of a model which is today no longer functioning, which is the WTO model, panels and appellate body. And so this is one of the challenge for the negotiations of the investment protocol, is how do you put in place a dispute settlement system that is actually adapted to investor state dispute settlement, and how do you make sure that questions like enforcement are there? And if you want to be realistic about that, you know, the answer is that it's very hard to just create a a self-contained African system of arbitration that is totally disconnected from what has been already put in place, for instance, with the New York Convention or the ICSID Convention. And so people like me, at least from an academic perspective, you know, I don't want to say whatever I would say in some of these meetings, but from at least an academic perspective, I believe that we need to build upon, you know, those universal mechanisms that are there. It's one thing to say, let's Africanize investment arbitration. For me, Africanization of investment arbitration means let's make sure that arbitration occurs in Africa. Let's make sure that maybe more Africans are involved in arbitration. Let's make sure that some of our concerns regarding the traditional model of investment arbitration are taken into account. So for instance, reducing the offer to arbitrate, allowing for counterclaims. So I think we can Africanize investment arbitration without totally, contracting out from what we have already accepted and which can still be useful for our countries. Why would we get rid of ICSID if ICSID can be useful, to African countries in managing their disputes? So this is what I would say, but there is no yet technical discussion on enforcement.
Thank you very much, Professor Gourgourinis. Tassa, would you like to add some comments on these issues before giving the floor to Professor Giannakopoulos?
No, I'm fine for now. I have covered.
Thank you so much. Professor Giannakopoulos, you have asked a question through chat on decolonization of investment law. You may wish to raise it in person, so to say.
Thank you, and thank you to Makane, of course, for the excellent talk, and to Tassos for the comments, and to the Athens PIL team for the organization of this. I mean, this may be more of a general question. I really liked Makane's reference to the resurrection of the drive for a new international economic order, and so what I really wanted to ask is whether he feels sort of like perhaps with Africa spearheading this, the time would be ripe for sort of like a campaign for the decolonization of investment law as it now stands. So going beyond sort of like Africanizing, as he puts it, international investment law, to what extent we can see sort of like connections perhaps with South American moves of exiting the system or of reforming the system, and even European moves for reforming the system towards a type of decolonization of investment law as it now stands, especially given the fact that, as I said in the chat box, sort of like Poulantzas and others in the 70s, they made a point out of characterizing investment and investment law, for that matter, as a vehicle for effectively soft or new colonization. So this may be taking it a little bit too far, but I was wondering whether perhaps sort of like Africanization of investment law might spearhead sort of like a new movement to that effect, which the South Americans sort of tried to start but didn't really succeed earlier in this century.
Thank you so much, Antonius. Thank you so much for the excellent question and comment, and thank you for being here. It's great to see you here. No, but I think African countries, together with other developing countries, have tried. I think that what happened during the 60s and 70s with the battle for the new international economic order was a sort of attempt to decolonize international investment law. We remember that those countries rejected certain standards like the Hull standard. If you check Resolution 1803 on permanent sovereignty over natural resources, or Resolution 3281 on the Charter on economic rights and duties of states, this was like rejection of the dominant thinking of the Western world. We refused to say that compensation should be prompt, adequate, and effective. We said it should only be appropriate. And when you look at the Charter on Economic Rights and Duties, we actually even rejected that disputes regarding compensation should be settled via international arbitration, but we say via domestic courts. So we've been there in attempting to decolonize, and it didn't really work. The approach of decolonization, if you not only from a theoretical perspective but from a practical perspective, you may remember, Antonius, what happened in the Texaco versus Libya case in 1977, when Professor René Jean Dupuy, who was the sole arbitrator there, basically rejected that all resolutions for the battle for the new international economic order really could contest the dominant thinking of Western countries, or the dominant vision of the Western countries regarding the investment regime. And his position, the position of René Jean Dupuy at that time, was to say, okay, you are a bunch of developing countries trying to change the system, but at the end of the day, those those who are the main actors of the international economic system. So those who are capital exporting countries, those who are the biggest player in the global economic system, they've been voting against your resolution. They've been abstaining regarding your resolution. So those resolutions simply do not have any legal value to produce. So we've been there. We've been there, and that's why, you know, I'm among the people who sometimes are a bit, you know, cautious with the idea of decolonization. I know that many of the great colleagues and friends, in particular, those coming from third world approaches to international law, are very keen in using the word decolonization. But I'm not sure that this is actually the way to go, because decolonization implies we're getting out. And I think we should get in. I think we should get in. The challenge for us in Africa is to have an African voice, that when scholars, when practitioners speak about investment law, that they think about referring to the bilateral investment treaty between Morocco and Nigeria. When they speak about, you know, reforming investment arbitration, that they think about, okay, let's look what COMESA is doing. Let's look what they're doing at the level of the AFCFTA. For me, I think that this is what we need as a continent. Being there, having a voice, and that people do not make the future, that they don't build the future of international investment law, you know, without Africa, because this has already happened. And then we need now to take advantage of the present momentum to make sure that this time we build together and we are there, we have a voice. So this is why I would prefer, you know, Africanization than decolonization.
Thank you very much. I see that Antonios says that makes a lot of sense. And I'd like to give now the floor to Professor Pasatzis. Faye, you have the floor.
Thank you. And this has been a very interesting discussion. So I'm not an investment lawyer, I'm not a practitioner, but I wanted to ask some questions to Makane in his very interesting discussion, especially on the rationalization of investment standards. So if I understood correctly, I mean, there's the idea to say that, you know, most standards or some standards can be positive or good, but need to be connected to objectives within, you know, the Africanization or within the African continent. And if I heard correctly, Makane suggests to exclude, for example, the fair and equitable treatment standard. And I know from what I know, from the little I know, I mean, that is the FET is something we see across the board in investment arbitration. I mean, it seems like a general principle, if you wish, or something customary. And I'm wondering how and if, you know, it could be done away with. But that's just a question that came to my mind as I was listening to this. And from the, I would like some sort of reaction, because
thank you so much, Professor.
Professor Mbengue, and then also Professor Gourgourinis, he may wish to add some comments. Professor Mbengue.
Yes, thank you so much, Professor Papadakis, for this very provocative question. You know, at that level, I think I would join Antonios and say, there we need decolonization. There we need decolonization, because I think that, you know, FET is bringing a lot of problems. When you pay attention, it is a standard that is there, but then investment tribunals do not really agree on, you know, what is the meaning. Is it the customary standard of minimum standard of treatment of foreigners, or is it something broader which would encompass the legitimate expectations of foreign investors? So you have different positions among investment tribunals, but you have also different views among states. You know, if you take CETA, if you take the Comprehensive Economic and Trade Partnership Agreement between Canada and the European Union, you would find FET, but then with Canada and the EU trying to limit as much as possible the scope or the meaning of what FET is about, and bringing it back to its classical, traditional, connection with the minimum standard of treatment of foreigners, and then you would go in other treaties or regions. FET has a more elastic definition. So I think it's really a standard that is creating a lot of trouble in the investment regime, and I don't believe that it is customary. I actually don't believe that there's a lot of customary investment law. Maybe something that is customary, is the right of states to expropriate, and then their duty to pay compensation if they expropriate. But then when it comes to the rest, I'm not among the people who believe that these investment standards, are actually standards that have to be necessarily integrated in investment agreements. We in Africa, in the context of the current negotiations, we're saying maybe we don't need FET. Maybe we can go for fair administrative treatment. If you check the Southern African Development Community model of 2012, it says there's alternative to FET, fair administrative treatment. So what would be fair administrative treatment? It would be about making sure that a state does not subject a foreign investor to discriminatory administrative treatment, to manifest denial of justice in civil proceedings, criminal proceedings, etc. So there is another way. There is another way to guarantee that investors would be subject to a certain treatment under customary international law, but without necessarily calling it FET, because the experience, what we have learned after 50 years of investment agreements, what we have learned is that FET is more a problem than a solution. It's more a hurdle in the relations between investors and host states than how do you call that? A facilitator of a win-win relation. And that's why we do not want to go there, even if it is true that it is a principle that has been very, very much used in investment lawmaking. Thank you very much.
Anastasios, what about this semantic issue and symbolic issue, and the difference between fair and equitable treatment and fair and administrative treatment? Any reaction, any comment?
Makane. And thank you also all the other participants that they raised very good questions that actually led. International investment law, it is always peculiar that everything leads to FET. It's like a deja vu. Whenever discussion starts in international investment law, we all end up discussing fair and equitable treatment and customary international law. I don't know whether perhaps this is something that this is just semantics or something. But I would say one thing, that fair and equitable treatment is there has been an attempt by the European Union, actually by the European Commission, to somehow replace fair and equitable treatment by referring to general principles of EU law as being capable of providing equivalent protection to foreign investors, so that there is no need to resort to international standards such as FET. And although I was personally unconvinced by the reasoning and the analysis the European Commission provided, which was relatively brief, I must also add, I can see the point. And here, perhaps, the Africanization may have an extra impact, in the sense that the good administrative practices, the good policies, the good governance schemes that may develop or are already developed in the African continent could play a role in shaping the standard, because it must be admitted, and this is where Antonios is right, that the colonization of investment law is also reflected in the standards. the standards, the substantive standards of protection in international investment law are more versed towards towards the Western developed countries rather than understanding the realities that may appear in the developing world or in developed countries that do not follow the Anglo-American paradigm of governance and public administration. So I think that Africanization may also have a role to play, or regional attempts to rationalize, I keep what Professor Mbengue said, to rationalize substantive standards by putting them to the test of actual reality and reasonable expectations from both the executive and the legislative branch.
Thank you very much for those comments. We have another question. We don't see the person, OAF-F3. Can you hear us? Yes, you are there. Okay, thank you so much.
Hello. Yeah, thank you for organizing this interesting
you have the floor. With great pleasure.
Yeah, thank you. Yeah, I'm Justice Osei. I also want to thank Professor Makane for this interesting discussion. In fact, the issue of Africanization of international investment law has been gaining traction. And I have 2 points. The first point is about comments that I'll encourage that those of us in the academia will try to extend our method of engagement with our students as to how we can look at how African states perceive the idea of international investment law, which I think some of us have been doing a lot of work, research work into it. So I think it is a very interesting discussion that we are having. Now, my second point, maybe one would say it is highly philosophical or it's on the abstract. The point is this, that we asked Professor Makane about whether Africanization is about decolonization or a different term should be used. My point is this, that I think when we talk about Africanization, as he rightly noted in his presentation, it is about African states trying to have their own voice as to what international investment regime should be, or what international investment regime pertaining to African states should be or ought to be. But the point is this, that you realize that looking at the African Free Trade Continental Agreement, which is yet to be, I've heard that the draft is supposed to come out in September this year. But I haven't seen the copy itself. I've had conversation with those who are involved in it. But it appears that African states do not really have the voice to call it an Africanization of international investment law. It talks about FET standard being taken out. But if you are to look at what is being negotiated now, it appears that it is the same standards of treatment which has now been replicated by African states. I think it is something that the negotiating team should look at it, because I understand that even the African states, parliaments of African states do not even have a voice as far as the African Free Trade Continental Agreement is concerned. And if that is the case, I don't think that African states do really own the Africanization of international investment agreements. Thank you very much for this interesting discussion. Thank you.
We thank you very much for your most interesting comment. Any comments on this question?
No, thank you so much, dear colleague. No, but I totally agree with him that there's a need also to ensure a bit more transparency. There's a need to ensure more public participation. I think Africanization without, broader participation from the African people in these processes limit the scope of what we can call Africanization. And I agree that there should be more voices. I've been among the ones actually bringing the attention of member states on the need to actually ensure more public participation. And even the guiding principles, the guiding negotiating principles of the investment protocol speak about the need to ensure, you know, transparency and public participation in the process. And I totally agree that this is something we need to make efforts on. Now, when it comes to the standards, it's true that it's hard to totally exclude all investment standards. I mean, how do you exclude national treatment from an investment agreement? How do you exclude MFN from an investment agreement? How do you exclude you know, how do you call that, full protection and security? How do you do that? I think that there are certain standards, they need to be there, but then given an African flavor, given an African touch. And that's why I was saying that for me, decolonization is not necessarily the right path, because decolonization means you reject. And we should not be in a process of rejection. We should be in a process of integration and then adjustment of those standards to the African needs. But when it comes to FAT, for instance, fair administrative treatment, I think that this is something that has been pushed a lot by African countries since the SADC model. So there are certain standards that are there that are very African, like the investors' obligations. Once again, socio-political obligations, you would not find it anywhere in the constellation of investment agreements. So yes, I agree with our dear colleague that much can be done for the Africanization, and this is actually the message that I sent in my presentation. But we need also to acknowledge that something has been done, because if we do not acknowledge that Africa has really achieved certain steps in making its voice being heard, in being a rule maker, then we always stay in the same, you know, background in which we've been staying for the last 40, 50 years. So I think it's also important to valorize some of the achievements that have been made, no matter if we consider that those achievements as small or big, but at least valorizing them. Thank you so much for your excellent points.
Thank you very much for this reply, this opting in reply versus opting out issue. So now I would like to give the floor to Mrs. Niroshika Liana Muhandiram. Please, you have the floor.
Yes, thank you very much, sir. Professor Makane, my question is that I have seen in many recent bilateral investment agreements of Africa have incorporated public interest concerns, especially as you have mentioned, Morocco, Nigeria BIT, and especially Morocco model BIT. So can you briefly explain the practical application of these BITs, and are there any recent cases emerged from these BITs? Thank you.
Yes, thank you. Thank you so much, dear colleague, for the very interesting question. Well, you know, I think something, and I think that this brings us back to what Anastasios was saying, that complexity can be a virtue. You know, there is a lot of cross-fertilization right now in Africa. So this idea of public interest that you find in the Morocco-Nigeria bilateral investment treaty is actually inspired from the Pan-African Investment Code. You know, the Pan-African Investment Code came and say, you know, we need to emphasize public interest. We need to emphasize the rights of states, development objectives. You have a whole chapter of the Pan-African Investment Code, which is called development-related objective, which is all about the public interest. And, you know, once I was in a UNCTAD meeting here in Geneva, and there were the negotiators from Nigeria who are very good friends, and I was telling her, my sister, you know, you should have mentioned the Pan-African Investment Code in the preamble of the Nigeria Morocco bilateral investment treaty, because you've been taking inspiration from that. So you have this all cross-fertilization in Africa, But at the same time, you have this competition where you would take inspiration, but you don't say where you're taking inspiration. So you don't build an African, or you don't build an African, investment law, because then you would read it like you would read it and you would think it's just the Nigeria Morocco BIT that is talking about that. So we really have this challenge. Now, of course, one has a challenge, and I think this is also in line with what Andreas was mentioning about enforcement. The other challenge is also implementation. It's also implementation. We have all these beautiful African visions and African legal instruments, but we have also now the challenge of how do we implement them? If you take, for instance, COMESA, the COMESA investment agreement of 2007 never entered into force. It never entered into force. Then they had to renegotiate a new one in 2017. So we don't know whether this one will enter into force. Pan-African Investment Code, as I've said, at the end was just converted into a soft law model and not a treaty. The bilateral investment treaty between Nigeria and Morocco, that is quite often referred to as a gold standard, has still not yet entered into force. Nigeria has not ratified it. Morocco has ratified it, but Nigeria has still not ratified the bilateral investment treaty with Morocco. So we have also this challenge of owning the process. We cannot just limit ourselves to say, okay, look, we have very beautiful progressive legal instruments, but then what do we do with them? How do we implement them? And this is why you have not yet heard about investment arbitration based on those agreements, because they have not yet entered into force. And those who entered into force, like the SADC Protocol on Investment and Finance in 2016, the SADC countries, took out the consent to investment arbitration from that protocol to make sure that no investment cases would be brought against them. But yes, we have this challenge of how do we implement public interest. But we need also states to accept that investment protection is not just about public interest. I'm thinking about what happened with the SADC tribunal 10 years ago when the SADC tribunal decided to take a judgment against Zimbabwe because of an investor that brought a case against Zimbabwe before the SADC tribunal. And then the reaction of the SADC state was to close down the tribunal, because they did not like the tribunal taking position against the state and also withdrawing the possibility from individual complaints. I think we need a balance. We need a balance. And some of us who are very much pushing for Africanization, this is what we write. This is what we tell to governments when we are consulted, when we are involved in negotiations. What we tell them is that Africanization should be about balance. The Western approach that Andreas was referring to was about imbalance. It was about asymmetric investment agreements. What we need is to reconcile and build investment cooperation. The future of investment law should be about investment cooperation and investment facilitation. And the African culture is about cooperation. Let's cooperate and let's find win-win to get together. Thank you very much.
Thank you so much for speaking about cross-fertilization versus competition, the challenge of implementation, about balance. Anastasios, a very last comment, and then I'll give the floor back to our director, Professor Papadakis. Anastasios.
Thank you so much. Let me just say that I echo what Professor Mbengue just said about how the international investment law of the future is about cooperation. And I think that cooperation, not only in terms of providing incentives, but also in terms of investment facilitation, has the capacity of actually making, let's say, the bad side of investment law, meaning substantive protections leading to arbitration against states, go away, in the sense that at the end of the day, investment law is not about settling disputes, it's rather about creating favorable conditions for the making of investments. So if investment law starts focusing less in the litigious part and more in the part of creating those conditions necessary to foster sustainable investment, I think that we will be discussing investment law in a more pleasant way in the future. So this is from me. Thank you very much.
Thank you very much. Thank you very much, both of you, and especially our invitee, Professor Mbengue. Thank you very much for being with us and developing with conviction and passion this extremely interesting issue, giving a brilliant lecture. And with this, I would like to call my dear colleague Faye to say a word before closing the event. Faye.
Thanks, Alexander, and thanks to you for this excellent moderation. I want to extend our thanks to Professor Mbengue. It was good to have you with us. You have a group of admirers here in Greece, sir. And of course, Anastasios and the friends I saw on screen, online. Good to see you all, Andreas and other colleagues. Let me say that this whole idea, because, you know, give due where due is due, is also an idea of our conveners, our young Athens PIL fellows and researchers. So I want to thank them, Dr. Nikolaos Voulgaris, Dr. Akis Papastavridis, Ms. Matina Papadaki, and our youngest, Dimitris Panoussos, who's also doing the YouTube and things I don't understand in technicalities. But thank you all. Alexander, thank you very much. Thank you for this. And good evening to all of you. Good evening to Geneva.
Thank you. Thank you very much.
Thank you very much. Thank you. Thank you so
Bye,
much.
Makane. Take care.
Merci beaucoup pour l'excellente modération, Monsieur le Président.
Merci infiniment.
Merci.